Hi, founders, inventors, and CEOs. A common problem that I find is that a lot of people twist or try to use either a non-disclosure agreement or a work-for-hire agreement for something that it should not be used. So in this video, I just wanted to explain each of those documents a little bit, go through some very simple ones that I have prepared that if you click on the link below, you can actually get copies of. So let's first discuss what is a non-disclosure agreement, NDAs. You'll hear about them a lot. They're essentially a contract to keep your information confidential. They can be mutual or non-mutual, meaning that they only protect one party. The simple one that I'll show you is just a one-way unilateral non-disclosure agreement, which would be something you would use when you're speaking to people to protect your disclosures. What you need to know is that if something is out there publicly or something could be found out another way, it's most likely not going to be protected by a non-disclosure agreement. Likewise, if you're already selling a product, if you're going to pitch someone and you're selling a product, pitching a potential investor, the product, whatever customers can see, whatever is publicly visible, is not going to be protectable by an NDA. And if an investor or someone you discuss this with can essentially reverse engineer based on that, there's no protection to that. But maybe some of your numbers, some of the things that you're planning to do that are not yet publicly disclosed, that would be covered as being a trade secret, as being confidential, and not disclosed to third parties already. So in cases where you're working with maybe a potential partner where they're also sharing information with you, is more of where there would be a mutual non-disclosure, where whatever each party discloses to each other would be protected and covered under that. And this basically what I'm showing you right here is an outline or a draft of a blog post that I'll be putting up also, that I'll link to at the bottom of this video. Works for hire are different in that they are for when you actually are hiring someone. You want to ensure that whatever they create for you, you own. And this comes in two real key places: in copyrights and in inventions, which are covered by patents. So under copyright law, whoever puts pen to paper, whoever fixes it in a tangible medium, whatever the work is, whether it's a photo, video, blog post, a logo, some sort of graphic design, whoever fixes it in a tangible medium is considered the author, and they own it. It doesn't matter that you paid them. It's whether or not they transferred ownership of the copyright to you. So a lot of clients come to me and say, hey, we paid that person for it, we own it, but that's not the case. You might have an implied license to use that logo or whatever the independent contractor created for you, but if you wanted to change that logo around in the future, change that blog post around that independent contractor created for you, you really need the right to create a derivative work of that, which would be covered under a copyright. So it's always best to ensure that they execute a work for hire, so that this way the rights are being assigned over to you. And we'll go into, when we look at the work for hire, a little bit more about the language for that, because it's very important. Like I said before, one of the big pitfalls I see is just people try to twist a non-disclosure agreement into a work for hire, try to twist a work for hire into a non-disclosure, because sometimes, especially a work for hire might have some confidentiality provisions in it. But it's not the same thing as having a non-disclosure. Normal process would be, maybe you're going to work, a lot of our clients work with product designers or engineers. And what they'll do is, when they're first speaking to them, they'll speak to them on a high level and have them sign a non-disclosure agreement, seeing if this is something they can work with. Maybe they have to give a little more information so that they can actually get some sort of estimates and quotes and have a better understanding. And then once they hire the person, a lot of the product designers, a lot of graphic designers have their own contracts that then will spell out who is going to own what intellectual property, what's going to be continued to maintain confidentiality, things like that. So we have a simple work for hire that can be used, but depending on who you're working with, they may have their own, and you should definitely review that, make sure that it really covers you and not them. So again, going on what the project is would determine whether you can just use a basic non-disclosure or a basic work for hire, or if you need something more that's really drafted to your situation. But let's jump into some quick and easy, simple non-disclosure agreements that are templates that we have that, as I said before, there'll be a link at the bottom of this video where you can get a copy of it yourself. So, first is going to be who's the disclosing party, who's the receiving party. So this is a unilateral. This is not mutual. Sometimes in a mutual one, it will say who the two parties are, and then just say whoever discloses work confidential information is deemed the disclosing party, and whoever is receiving for that. But either party during that mutual non-disclosure could be the disclosing party or the receiving party, or vice versa. So here, it lays out basically what it is, what covers the confidential information. Usually some sort of information that is secret, that is not well known, a trade secret, product ideas, clients, customers, vendors, pricing, policies, things that are not known out in the world. And the other party has the obligation to, not disclose it, and are only using it for a specific purpose. Evaluate and engage in discussions concerning a potential business relationship, or consider investing in the business. Like I said before, exclusions are, anything that was already known before this was signed, anything that's publicly known, things like that. We also have in ours just that, they're not going to try and reverse engineer or somehow circumvent disclosing parties' rights there. Any intellectual property gained from it is, maintained by the ownership of the disclosing party, that the receiving party will return all materials. This one governing law here is New York. I'm a New York attorney, so this is limited for use in New York. If you're going to use it outside of that, you should have a lawyer in your state look at it. And that's just, this is a very simple, basic one. I would use this for if you're speaking to a graphic designer, if you're speaking to a product designer initially, if you're speaking to a potential investor, at the initial stages. That's where this is good, because it's very simple. Then we have a work for hire agreement. Work for hire, so a lot of the language in a work for hire could also be part of an independent contractor agreement that you might see. So, again, it's going to spell out who the parties are, who's doing what are the services that you're hiring this independent contractor for, or this artist. Are they drafting and editing or creating a logo? Are they creating marketing material, social media posts, photographs, videos, blog posts? You're going to want to spell out what it is that they're doing. You're going to try and want to be very detailed. If it is an independent contractor, you're hiring them for a specific job, not trying to take an employee and twist them into an independent contractor to avoid having to deal with all the employment issues, because that's a whole other thing that you should speak to your employment attorneys about. But I know that that's something that's done. You get people that are asking for things that are just like, I want to cover too much, when it's not really the right type of agreement for that. What they're really looking for is an employee, not an independent contractor. And then it talks about the payment, the relationship of the party. But here's, where the key language of the work for hire. And again, this one is very basic work for hire. The real key about this one is ensuring that you own the intellectual property that's created. So it says you acknowledge and agree all concepts, ideas, inventions, copies, sketches, artwork, electronic files, and all artistic, literary, dramatic, musical, and other materials submitted, created, or prepared by you in connection with your work for company. Now defined as the materials, together with the results and proceeds of any such material, are specifically commissioned by company as works made for hire under the copyright laws of the U.S. and all other nations. Accordingly, company is the author and owner of all right, title, and interest to the material. So what we're saying here in English now is that all this work that you're doing, the company is specifically commissioning, because that's language from work for hire laws, and that they will be deemed the owner as of the time of the creation, rather than you, the author. A work for hire, there's really only limited categories that it falls into. Attorneys and many other people all say, work for hire, but we're talking about not just the work for hire part, but this part also that I think is very important, because if any of the materials is determined not to be a work made for hire, you hereby irrevocably and unconditionally assign, as of the time of creation of the materials, all right, title, and interest to the materials, including but not limited to all copyrights in the materials. And this is key, because if it's a work for hire, just like if that basically treats the author as an employee for copyright purposes. And what that means is if you're doing the work within the scope of your employment, your employer owns it. So that's how it's treated under work for hire, so that basically the company that commissions it is considered the author. However, if it doesn't fall within those specific categories that I mentioned, it will actually be that the author, the contractor, is considered the author. So here, by adding in this language here about it, if it's not determined to be a work made for hire, we're saying that as soon as you created it, you had an obligation, a legal binding obligation, to assign that over to the company. And generally what we would do in most cases then is, at some point, especially if it's an invention, we're going to have a whole separate assignment agreement that the person would have under this, an obligation to sign. And that's really the keys. And here we also have some warranties about, like, if they're using work, they're making sure that they're clearing it. So especially in graphic design, in video, in music, if someone is bringing in other work, we want to make sure that they got the proper license to do that, so that our client can be held accountable for it. And of course, if there's a much bigger project where there really is a lot of work that's coming in that needs to be licensed, you're going to want something more robust than just this simple agreement to do it. And then similarly here, we do have some confidential language and non-disclosure language to protect you. But if at an earlier stage you were working with a person or talking to them to even discuss this potential to work together, you should have used the non-disclosure agreement. So that's just walking you through some of the basics of these two simple non-disclosure and work for hire agreements, and what the difference are between them, different situations to use them. So I hope you find it helpful. If you like these, please click like below, subscribe. And as I said, if you click on the link below, there'll be a place to actually get these two templates. And thank you for watching, and have a great day.